A guide to the impact of social media and custody in Cherokee County. Social media and custody cases are more interconnected than many people would expect. Social media has become part of everyday life for many Oklahoma parents. Platforms such as Facebook, Instagram, TikTok, Snapchat, X, and others allow people to share photos, opinions, vacations, relationships, and daily activities with friends and family. While social media can be a useful way to stay connected, it can also become a significant source of evidence in a child custody case. Social media is often used as evidence. One of the biggest misconceptions in custody litigation is that social media activity is private. In reality, information posted online frequently becomes evidence in family court cases. Attorneys often review social media accounts looking for content that may be relevant to issues such as parenting ability, honesty, judgment, substance abuse, living conditions, or compliance with court orders. Even posts that seem harmless at the time they are made can take on a different meaning when presented during litigation. Judges understand that social media often provides a glimpse into a person's lifestyle and decision-making, making it a valuable source of evidence in some cases. The court focuses on the child's best interests. In every Oklahoma custody case, the court's primary concern is the best interests of the child. When reviewing social media evidence, judges are generally not interested in whether a parent enjoys vacations, social events, or hobbies. Instead, they are looking at whether the content reveals behavior that may affect the child's safety, stability, or well-being. For example, posts showing excessive alcohol consumption, illegal drug use, dangerous conduct, criminal activity, or repeated poor judgment may raise concerns about a parent's ability to provide a safe environment for a child. Negative posts about the other parent can cause problems. Many parents feel tempted to vent frustrations online during a custody dispute. Unfortunately, those posts often become evidence. Courts generally want to see parents who are willing to foster a positive relationship between the child and the other parent whenever it is safe to do so. A pattern of hostile social media posts attacking the other parent may create the impression that a parent is more interested in conflict than cooperation. Judges frequently view public arguments, insults, and attempts to embarrass the other parent negatively, particularly when children may eventually see the content. Social media can affect credibility. Credibility is one of the most important factors in any custody case. If a parent makes statements in court that are inconsistent with their social media activity, those inconsistencies can become a significant issue. For example, a parent who claims financial hardship may face questions about photographs showing expensive vacations or luxury purchases. Likewise, a parent who claims to spend all available time with the child may have difficulty explaining posts that suggest otherwise. Even when the content does not directly affect custody, it may influence how the court views a parent's truthfulness. Private messages may not stay private. Many people assume that only public posts can become evidence. That is not always the case. Text messages, direct messages, private chats, and other electronic communications are often introduced during custody litigation when they relate to parenting issues or disputes between the parties. Messages involving threats, harassment, attempts to interfere with visitation, substance abuse, or discussions regarding the child can become important evidence. Parents should exercise the same caution in private communications that they would use in public posts. Friends and family can create problems. Not all damaging social media content comes directly from the parent involved in the custody case. Friends and family members frequently post photographs, comments, and tags that may later become evidence. A parent may never have uploaded a questionable photograph, yet still find themselves explaining it in court because someone else posted it online. For this reason, parents involved in custody litigation should remain aware of their overall online presence, including content shared by others. Deleting posts can be risky. When parents realize certain social media content may be harmful, their first instinct is often to delete it. However, deleting information after litigation has begun can create additional problems. Courts may view the destruction or removal of relevant evidence unfavorably, particularly if it appears the content was removed to prevent its use in court. Before deleting social media content that may be relevant to a custody case, it is often wise to consult with an attorney. Less social media is often better during litigation. One of the safest approaches during a custody dispute is simply to reduce social media activity. Many family law attorneys advise clients to avoid posting about the custody case, the other parent, new relationships, financial matters, vacations, the children, and court proceedings. The fewer opportunities there are for misunderstandings or misinterpretations, the less likely social media will become a problem during the case. Tahlequah family lawyers. Child custody cases involve far more than courtroom testimony. Social media posts, text messages, emails, photographs, and electronic communications can all influence how a judge views the evidence and the parties involved. Because a single social media post can sometimes affect the outcome of a custody case, parents should carefully consider their online activity and seek experienced legal guidance whenever a custody dispute arises. Our team at Kania Law, Tahlequah Lawyers is here to guide you. Call 539-867-2321 today for a free and confidential consultation with one of our child custody attorneys.